Hello and welcome to our panel discussion on the remaking of the courts and why you should care. I'm Kenneth Upton, Senior Legal Counsel for Americans United, and I know that some of our conference programs have focused on advocacy opportunities with elected officials, but we want to call attention to one of the more powerful tools AU and many allied organizations have. That's the ability to go to court and to sue. In recent years, many lifetime appointments to fill our federal courts have gone to judges who have demonstrated a willingness to permit some religions to wield their beliefs as a sword, to cut away at the rights of others, and avoid complying with laws that the rest of us must follow. So today we're going to take a look at how the changing courts could result in a government that permits religion to dictate public policy and authorize discrimination against minorities. Today, I'm joined by Sharon McGowan, Chief Strategy Officer and Legal Director for Lambda Legal, and Heather Weaver, Senior Staff Attorney with the ACLU Program on Freedom of Religion and Belief. Welcome to you both.
Hi, thank you.
Heather, let me ask you to start us off with our discussion by reminding us of the importance that the courts have played in shaping the role of religion in our society.
Sure. Well, thank you, first of all, Ken, for hosting this panel. And it's really great to be here today with Sharon. So when we're talking about remaking the courts, I think it's important to take stock of some of the core principles governing the separation of church and state that are now at stake. We'll get deeper into the case law later, but there are a number of fundamental constitutional tenets that have been well settled that are now at risk. First, for the past nearly 40 years, the Supreme Court and the lower courts have generally upheld the principle that the government may not favor or promote one faith over others or target one faith for disfavorable treatment. We saw that tenet enforced in the 1982 case, Larson v. Valente, which struck down Minnesota's Charitable Solicitations Act because it was effectively gerrymandered to make it more difficult for an unpopular religious sect there, the Unification Church, to raise funds. We saw that principle enforced in 1994 in the Curious Stroll School District case. That's when the Supreme Court struck down a New York statute that created a special school district to benefit a particular Hasidic sect. We've seen it enforced generally in the context of government-sponsored religious displays, although the court has gotten the application of that principle wrong in some cases, even before the current court's tenure. And we've even seen the principle enforced in one of the worst Establishment Clause cases, at least one of the historically worst Establishment Clause cases, Marsh v. Chambers, where the court nonsensically upheld legislative prayer, but at least the court relied on the fact that the prayers at issue in that case were ecumenical and not specific to one particular faith. But this principle, which has been fairly well established in the last 40 years, has been eroded by the Supreme Court in recent years and the lower courts following suit. If you look at the Muslim ban case, the Town of Greece case, which allowed what we call sectarian government-sponsored prayers, and the American Legion case, which upheld the government's display of a 40-foot tall cross, you see that the idea that the government can't favor or promote one religion or single out one religion for targeting, for disfavor, that idea, which is so fundamental to the First Amendment and the Establishment Clause, is being chipped away at and eroded in a very troubling way. The second principle that is at risk as the courts are being remade is that the idea that the government may not directly fund religious activities. And by the way, that refusing to do so is not discriminating against religion, but rather is protecting religion. And it recognizes the harm that occurs when the government finances it. So we first saw that enforced in a seminal Establishment Clause case, which I'm sure many of the viewers of this panel are aware of, Lemon v. Kurtzman in 1971, where the court held that the government could not pay the salaries for teachers at religious schools. That sounds pretty straightforward and is a solid principle, I think, especially when you consider James Madison's views on the funding of Christian teachers. We saw the principle upheld 2 years later in another case in Leavitt v. Committee for Public Education, where the court ruled that direct money grants for religious schools to provide grading and reporting of exams was unconstitutional because there was no way to ensure that the exams didn't include religious content and instruction. And even as recently as 2004, the Supreme Court recognized in Locke v. Davie that even if some types of government funding, like school vouchers for religious education, didn't technically violate the Establishment Clause, states were certainly not required to provide such funding to schools. But again, these principles have largely been vitiated by the court in recent years. We saw it in the Trinity Lutheran case, where the court held for the first time ever that direct government funding to a church was required under the First Amendment. Of course, in that case, the court claimed that the funding was for a purportedly non-religious purpose, which was resurfacing playgrounds. And earlier this summer, which we'll get into this case more later, we saw the court's ruling in Espinoza, where it held that the state of Montana must allow government funds to be used for religious education as part of a tax credit school voucher program. Third principle that is at risk right now with the courts being remade is the court's historical understanding that the government may not give religious accommodations or exemptions if those exemptions or accommodations harm others. We've seen that in a variety of cases. Just to give a few examples, in 1985, in a case called Thornton v. Calder, the court held that a Connecticut law giving employees an absolute right not to work on the Sabbath violated the Establishment Clause. Why? Because it imposed a burden or harm on those who did not observe the Sabbath day. They would have to work in place of those who had the absolute right to take the day off. In 1989, in Texas Monthly v. Bullock, a plurality of the Supreme Court invalidated a sales tax exemption for religious periodicals, in part because it would have harmed non-beneficiaries by increasing their tax bill. Even when the court has approved certain religious accommodations or exemptions, it has gone out of its way to note that the exemption does not harm or burden others. Again, we'll get into this more later, but that principle is at stake as the court has applied the federal religious exemptions law, which is called the Religious Freedom Restoration Act, to allow businesses to be exempt from rules requiring contraception coverage for their employees. And as the court has adopted a more expansive interpretation of the ministerial exception, which exempts certain religious employees from non-discrimination laws with respect to so-called ministerial employees. Also, in the context of religious exemptions, the court has expanded the scope of its quote-unquote hostility to religion doctrine so that some religious actors get exemptions they would not otherwise be entitled to whenever there is even the most milquetoast criticism of the religious entity. And we saw that in the Masterpiece Cake Shop case. So these issues will come up again next term in the Fulton v. City of Philadelphia case, which is an ACLU case, or we represent, I should say it's not an ACLU case, the ACLU represents interveners in that case. And the court will decide there whether a religious foster care agency, Catholic Social Services, has a constitutional right to get a government contract to provide services and then discriminate against prospective foster families based on their LGBT status. Finally, and this one kind of pains me because I do a lot of work in this area, over the past 50 years, the Supreme Court has made clear through its jurisprudence that public schools are safe havens from official promotion of religion. In 1962, in Engel v. Vitale, the court struck down a New York state law requiring morning non-denominational prayers at public schools. In 1963, the court overturned a Pennsylvania statute requiring morning readings of biblical scripture in public schools. Over the years, the court has stymied efforts by religious advocates to promote creationism in public schools and prohibited the display of the 10 Commandments in classrooms, moments of silence that were intended to promote prayer, graduation prayer, and prayer before football games. So the Supreme Court hasn't accepted a case involving the promotion of religion in public schools in almost 20 years, but it is coming, and it could be disastrous for minority faith and atheist public school students when you keep in mind the remaking of the courts that is going on right now. So when we talk about what's at stake with the remaking of the courts from the perspective of the separation of church and state, we are talking about some very significant changes. And over time, it really can mean the whole ball game, depending on the direction that the courts go. And every principle that we cherish when it comes to the Establishment Clause could be in danger.
Thank you, Heather. And Sharon, why don't you give us a little insight into what's happening. I know for the past few years, Lambda Legal's Fair Courts Project has been tracking what's been, what I've called the remaking of the courts. And maybe you could share your thoughts about what's happening.
Absolutely, Ken. Thank you so much. And thank you, Heather, for setting the stage in that really great way. You're absolutely right, that this is one of the most significant things that we have seen happen during the Trump administration. And I'm sure I'll say mine now. I'm sure other people will say theirs later. Just as a reminder, I am the legal director of Lambda Legal, a nonprofit 50c3 organization, so we do not engage in partisan politics. It is hard to talk about sort of the remaking of the courts without sort of recognizing the political facts on the ground that have allowed that to take place. But just to be clear, our advocacy in this space is a very important piece of what we think of when we talk about our educational work. And so I will be laying out these numbers and these statistics as a way to remind people about how important it is for your engagement in the political process, however you choose to do that, because this is not only a function of the president nominating individuals who will serve for lifetime appointments on the federal bench, but obviously to the extent that the Senate has an important role to play here in terms of advice and consent, those are other opportunities for you to make your voice heard and ask for your values to be reflected in the ways in which your elected officials play that role. And so it's wonderful to be able to have this conversation in the context of a conference that's designed to empower people to use their voice and speak to their elected officials to make sure that their priorities and their values are being reflected by those who are in Washington on their behalf. And so in terms of the remaking of the federal judiciary, I think we can look back with hindsight to the nomination of Justice Gorsuch to replace Justice Scalia. And we don't need to sort of go through the entire dramatic tale of how that nomination came to be, you know, the short version being Senate Majority Leader Mitch McConnell refusing in an unprecedented way to even consider the nomination of Merrick Garland during President Obama's last year in office. But when Justice Gorsuch was nominated, you know, we can sort of look back now and, you know, 3 years later and have perhaps sort of, you know, a more nuanced opinion about where Justice Gorsuch has landed himself, and certainly when it comes to LGBT issues and the most recent Title VII decision about LGBT employment discrimination. You know, these stories are often, you know, sort of more nuanced and complicated. But on this question of the court's approach to religious liberty and how we are going to make sure that religious freedom is not used sort of at the expense of other really important constitutional principles and social principles that we choose to govern ourselves by. The selection of then Judge Gorsuch from the 10th Circuit was really quite significant, in large part because he had been a champion of one of the more aggressive versions of the view of what kinds of government involvement constitutes a burden on religious liberty. And this came out in the context of the Hobby Lobby case regarding whether or not, you know, private for-profit corporations could exercise religious liberty interests in being able to resist the mandate in the Affordable Care Act regarding providing contraceptive coverage to their employees. His view was a more extreme view that was not, in fact, actually adopted by the Supreme Court in the ultimate Supreme Court decision in Hobby Lobby. But the fact that he was confirmed to the court, I think we are going to continue to see, you know, the fact that he came to the Supreme Court with that philosophy as not only sort of things that will influence cases to come, but really sort of a foreshadowing of what it was that we were going to see over the next 3 years in terms of the attempt to remake the bench. And this truly has been perhaps the highest priority area of this administration in terms of things that they've been able to accomplish that will have lasting effects and will in many ways sort of be playing out for generations. Because as we know, even though there are many, many horrifying things that this administration has done from a civil rights perspective, whether it comes to immigration, sort of racial justice, healthcare, the fact that these nominations are for lifetime appointments means that even after, you know, whether it is a one-term or a two-term presidency, these are individuals who will potentially be on the bench for 30 or 40 years and shaping jurisprudence for generations to come. And so the fact that there has been such a dramatic impact on the federal judiciary is something that it's really important to grapple with. And Lambda Legal's decision to get involved in this work was a reflection of the fact that we knew that there was in some ways an intensity gap between those who took a more progressive approach to civil rights and those who would like to see us roll back the clock when it comes to certain civil rights advancements that we'd made. And so we recognize that as an organization that uses the courts to advance LGBT equality and equality for people living with HIV, it was important for us to engage in some public education efforts as well to explain why the remaking of the courts would be so important to the larger issues that we work on. And so once we moved past the nomination of Justice Gorsuch and he was confirmed in April of 2017, we really saw, sort of a snowballing effect year over year of this administration working with the leadership in the Senate to overhaul, in many ways, sort of the federal judiciary with a number of very anti-civil rights, certainly anti-LGBT nominees, but also nominees that took much more pro-religion as a sword approach to these kinds of cases than we'd seen in the past. And just to kind of give you a sense of what I mean when I'm talking about sort of the cumulative effect, and I'm going to use sort of the LGBT lens, which is obviously the lens that Lambda brings to this work, as sort of one way to just sort of demonstrate that. By the end of 2017, we had 59 nominations to the federal courts, and we were able to identify at least 16 whose records demonstrated such a deep anti-LGBT bias that Lambda Legal, notwithstanding the fact that we potentially could be appearing before these judges were they to be confirmed, felt as though it was important to speak out and oppose their nomination. So that was 1 in 3 of all of the federal court nominees. And in particular, in that first year, we saw a number of nominees who really made quite a name for themselves in terms of their level of anti-LGBT bias. Jeff Mateer potentially being perhaps the most notorious because he was actually caught on video describing transgender children as part of Satan's plan. Apparently that was a bridge too far for some within even the conservative ranks, and so his nomination was pulled. But many other individuals who hold arguably as anti-trans, anti-LGBT views, but perhaps weren't caught saying something quite that explicit on tape, were advanced through. And among those were Matthew Kaczmarek, who was actually a colleague of Jeff Mateer at the First Liberty Institute, who'd been litigating many of these cases, was nominated for a district court position in Texas. And then Kyle Duncan was also nominated also for a seat in the Fifth Circuit, the area that covers Texas, Louisiana, and Mississippi. And notably, going back to Justice Gorsuch, Kyle Duncan was the advocate from when he was at the Beckett Fund, advancing this really extreme view of corporations having religious liberty interests that could be asserted against generally applicable non-discrimination laws and provisions like the contraceptive coverage provision of the Affordable Care Act. So his nomination was put forth as well. But we also saw other folks nominated, some of whom actually were so extreme that they were deemed unqualified by the American Bar Association, including Stephen Grass, who was deemed unqualified by the ABA for the position that he was ultimately confirmed for in the Eighth Circuit, in part because of his very, very extreme views, and in particular about his sort of the concern that he could not put his own personal anti-trans views, anti-transgender views aside in order to administer equitable justice to those who appeared before him. So by the end of 2017, we had 59 nominees, 1 out of 3 that we had identified as being so anti-LGBT that they warranted opposition. By the end of 2018, we saw that 1 in 3 trend continue, but that in particular, that 1 in 3 trend played out in the Circuit Court of Appeals, which, as many people know, is often the last stop on many cases because the Supreme Court's docket is so limited. And so in many cases, the decision from the Court of Appeals is the last word in that case. And by the end of the second year of the Trump administration, we had seen 30 appointees confirmed, which exceeded every president that had appeared in recent memory. The rough average was anywhere between 16 and 22 Court of Appeals nominees that had been confirmed, and the Trump administration had already achieved 30 by the end of year 2. So we saw a doubling of the confirmations in the Court of Appeals and an 8-fold increase in the number of confirmations to the district court level as well. So you could see this incredible push really taking every slot that was potentially available on the federal judiciary and having them filled by nominees from this administration. And notably, 85% of those who were nominated were members of the Federalist Society. And that affiliation is obviously incredibly important because we know that the Federalist Society has taken a very sort of public stance in terms of what direction they think the law should go, how they view religious liberty as trumping all of the other sort of constitutional issues that we care about in terms of civil rights. So the fact that there was this incredible sort of alignment between the Federal Society and who was being confirmed for the federal bench should also give us incredible pause. And then, of course, obviously in 2018, we also saw the confirmation of Brett Kavanaugh to the Supreme Court. Again, someone who made his name on a variety of issues, none of which we need to get into right now, but one of them being obviously sort of his particular stance around religious liberty, and certainly his record about the Affordable Care Act and trying to make sure that there were religious exit ramps, and the question of what kind of a burden could you put on a corporation is just filling out a form to get out of the contraceptive mandate too much of a burden. Of course, a case that wound up being litigated before the Supreme Court again this term. And then by the end of 2019, you know, again, we continued to sort of track the overall record. And again, we were still seeing 1 out of every 3 circuit court nominee having an explicit anti-LGBT record, which often in many ways means that they have an approach to the law that is dangerous with respect to sort of the First Amendment, dangerous with respect to reproductive freedom. We also obviously know that many of these judicial nominees refused to even confirm their view that Brown versus Board of Education was correctly decided. I think in many ways that was their way of trying to get out of having to answer the other question that was lingering about whether or not Roe versus Wade was correctly decided. But the fact that an environment had been created where a judicial nominee felt as though it would be acceptable to question the validity and the strength of a decision as seminal to our country as Brown versus Board of Education gives you an idea of how the political shift had happened with respect to sort of the ability to push forward so many nominees who were really so far out of the political and legal mainstream in order to remake what the philosophy would be of this branch of government that has such an important impact on people's lives. And so just to kind of wrap up, you know, sort of what the overall impact has been, you know, this past summer, we saw the 200th federal judge confirmed by the Trump administration. In terms of Court of Appeals nominees, we saw the 53rd Circuit Court judge confirmed by President Trump and his administration. For purposes of comparison, President Obama confirmed 58 circuit court judges over the course of his 2 terms in office. So the idea that we could be potentially sort of looking at 4 more years and at that pace, what that would mean in terms of the remaking of the courts of appeals. And then also to note that 3 of the circuit courts flipped actually from being either in a balanced posture or having more Democrat appointed judges to Republican appointed judges. We saw that this incredible push in terms of numbers has also meant sort of a shift in terms of what the overall political makeup is of these circuit courts. And I say all of this just to be clear, to note that not every Republican appointed judge is bad on these issues, and not every Democrat appointed judge is good in terms of how we might want to see these issues come out. But to the extent that so many of these judges have affiliations with organizations like the Federal Society and the Alliance Defending Freedom that exist for the purpose of advancing a particularly extreme version and philosophy of how to weigh these different kinds of liberty interests, that is really important for us just to understand, you know, what it will mean in terms of the ability of the courts to serve as a bit of a firewall against some of the more extreme things that we may be seeing promoted out of state legislatures or promoted, you know, from a federal government that is interested in advancing a certain view of religious orthodoxy that will come at the expense of not only LGBTQ people, but other religious minority groups, women, those who care about reproductive freedom, all other constituencies for whom the courts have often been a place of refuge from some of those kinds of activities.
Thank you, Sharon, for frightening us. So I guess the thing that would be most helpful now in our remaining time is to let you give some examples of cases that you're seeing, either cases recently decided or cases that you are watching come up through the court system, and express some of the things we should be watching for and some of the concerns that we should have based on what we're seeing as it plays out. So maybe Heather, you want to pick some cases, and we can just go back and forth between you and until we run out of time. And because heaven knows there's going to be more than enough cases to talk about. But I think it's helpful for people to take these abstract ideas and think about the real life facts of what's playing out in the courts. So Heather, why don't you start us out?
Sure. Well, I'll start out by talking about a case that's going to be heard by the Supreme Court this fall, November 4th, if I recall correctly. Fulton v. City of Philadelphia, I mentioned it earlier. The case involves a religious foster care agency, Catholic Social Services, that claims that it has a free exercise and free speech right to discriminate against prospective foster families who are LGBTQ as part of a government contract to provide those services. So the City of Philadelphia contracts out to various entities, including non-religious and religious entities, to provide services connecting foster children with potential foster families, and that requires that the agencies contracting with the city do so on a non-discriminatory basis. That's an across-the-board rule. Catholic Social Services wants to be able to discriminate, wants to be able to receive government money for the contract and to discriminate. They will not license same-sex couples to be foster parents based upon the agency's religious beliefs. They claim that they have a free exercise, like I said, a free exercise right and a free speech right to do so. We, the ACLU, represent interveners in the case. We're supporting the city's authority to require the foster agencies to accept all qualified families. And this is getting at a couple different issues that I talked about, a couple different principles that I talked about before. Of course, there's the issue of like government funding of like religious activity in the sense of like religious discrimination through a government contract. There's the issue of allowing sort of religious accommodation, or whatever you want to call it, religious exemption, even when it's going to harm third parties, which it is going to do here, both in terms of the prospective foster families and the children who will be denied a loving home because of this discriminatory view that the contracting agency is claiming. So the court's going to hear argument on that case in November. I think something that Sharon sort of pointed out, and I just think a lot of people don't realize this. Of course, this case is really about like this foster care agency really wants to discriminate against LGBTQ foster parents. But if the court were to say, sure, they have that free exercise and free speech right to do that, it really opens the door to discrimination on a variety of religious grounds. Discrimination against religious minorities. You don't, if against, a Catholic, adoption agency may not want to place children with, Jewish couples, or, vice versa. A Jewish adoption or foster care agency might want to contract with the state but not place children with Catholic couples. It can be used, there, as we've seen historically, there have been religion-based objections to interracial couples. And so an agency might be able to claim that right. It just opens the door to a whole range of discrimination where there's really no principal distinction. Once you say it's okay to discriminate for city contracted agencies to discriminate against LGBTQ foster parents, it opens the door to discrimination against all these other parents. It opens the door to allowing agencies to refuse to place children with couples who might take the children for certain types of treatment if that's against the agency's religious beliefs. There's just a wide variety of roads that this could go down. It's sort of a Pandora's box, if you will, and it would basically give religiously affiliated government contractors the right to dictate how public child welfare services and countless other government programs operate. So there's a lot at stake here, and we'll have to see. It's not the best sign that the Supreme Court took the case, but we'll have to see how the court comes out in this case compared to the previous case, which was a previous case involving the claimed right to discriminate despite non-discrimination law. That was, of course, Masterpiece, where the court said, well, in this instance, there was hostility towards the cake shop and Masterpiece, the owner, and therefore, that was a free exercise violation because they were targeted with animus. We'll see how this Fulton comes out. There is an argument that the agencies are making that the city somehow targeted the Catholic agency because of its religious beliefs. I think it's a weak argument, but that's one route the court could go. And of course, the court could also just sort of go on the full, very troubling route, which is that this is okay. It's a free exercise violation. Actually, in this case, I should note that one of the questions presented to the Supreme Court is whether or not its decision in Employment Division v. Smith should be overruled. In that case, as the viewers here may know, the Supreme Court held that, look, if there's a generally applicable neutral rule or law, you don't have a religious right to get out of it. And so that's just on the Free Exercise Clause, you don't have that right, okay? We can talk about later about whether there's a federal statutory right under other statutes, but you don't have a constitutional right to just ignore the law. And so the case has agreed, or the court has agreed to reconsider that case in this, reconsider that opinion in this case, and we'll see if they actually go so far as to overrule it. But there are a variety of possible outcomes that are very troubling should this court rule against the city. And I'll let Sharon jump in on this because she has a lot more to say.
Yeah, no, absolutely. Thanks, Heather. And I think that there's, this case is so important in and of itself, and particularly when you think about, sort of the fact that there are so many youth in our child welfare system, and it is their lives in many ways that are at stake, because the ability of religiously affiliated child welfare providers to use taxpayer dollars and then use their particular religious litmus tests to decide whether or not children will be placed in loving homes, who bears the burden of that, right? It is not only, certainly the LGBT prospective parents, but it's the children who are sort of left without sort of the full range of options simply because there is a particular sort of religious view that is cutting out a whole sort of area of potential homes. And that in many ways is one of the things that I think is so important about why this case is reflective of the way in which I think the opponents of equality and those who espouse a much more sword-like approach to how they plan to wield religious liberty is going to be playing out going forward, I think in part emboldened by the fact that they have made such ground in being able to populate the federal bench with individuals who they think will be more sympathetic to those claims. And again, in Fulton, part of the issue here is that you have the religious agency going after the city when what the city is trying to defend is a policy designed to protect people from discrimination. And so whether it's the ACLU needing to intervene or Lambda Legal needing to file an amicus brief or intervene in different cases where the voice of those who are being protected from discrimination can actually get back into the mix. Because if it's just the religious entity against the city without any discussion of who is in fact the intended beneficiary of the non-discrimination law, the conversation is inherently skewed, right? And while I think we have many great allies in government who are there able to defend the interests that they are trying to promote through the enforcement of their non-discrimination laws, to lose the voice of the victims of discrimination for whom those non-discrimination laws were enacted in order to benefit and protect is a way in which some of these conversations, I think, are skewed, and why it's so important for organizations like ours to continue to be in the mix. And relatedly, to the extent that we are seeing these kinds of pre-enforcement actions happening as well. In this case, there was a particular dispute where you had the Catholic agency, applying to be able to provide services and being denied. But in other circumstances, you have businesses that are being encouraged by organizations like the Alliance Defending Freedom to go in preemptively and try to get out from under generally applicable non-discrimination laws by saying, in many cases, either my religious liberty or my First Amendment rights will be violated if I am forced to provide services to LGBT people, often in the marriage setting, but not exclusively in the marriage setting. And so, guys, of course, certainly Masterpiece Case Shop was an example where there had actually been some enforcement action happening, but we're seeing these pre-enforcement cases in places like Minnesota, where we had Telescope Media, which was a wedding videographer company, basically say, our videos are our expressions of our views around marriage. And so you can't force us to video weddings that don't comply. I mean, again, the idea that somebody would go and seek their wedding videos done by this company that has their own particular agenda about what they want your video to be, you can decide whether or not that's where you would want to do your business or not. But those kinds of challenges normally would be thrown out on standing grounds. And in fact, actually it was thrown out on standing grounds, but then you had the 8th Circuit Court of Appeals with one of the Trump nominees that Lambda Legal had opposed, David Strauss, actually allowing the case to proceed by taking this, approach to the First Amendment interests of these businesses to not be compelled to speak about things like the legitimacy of same-sex marriage, or in any way sort of express through their provision of these services what are seen to be sort of views condoning or promoting marriages that they don't agree with. So again, we're seeing this not only sort of as a shift, but also I think a shift that is reflective of the fact that they think that the courts have shifted in a way that arguments would normally not really have carried very much weight, will now be viewed at with a greater level of receptivity as a result. So we're seeing it, again, in Arizona, there was a case involving a calligraphy company called Nib Brush. Again, a way in which, because there was an actual writing of words, they were able to sort of ground it in this First Amendment compelled speech doctrine. We had a case that is on its way to the 10th Circuit involving a web designer. Again, this notion of I'm being forced to say words on behalf of a client and I don't want to have to do that. Justin Walker, who has recently sort of been elevated, very, very close friend of Mitch McConnell, was on the district court in Kentucky and now has just recently been confirmed for the DC Circuit. Notable for his recent decision around whether or not, COVID restrictions can be applied in certain religious settings, but he issued one of his last decisions as a district court judge upholding a pre-enforcement challenge to a photographer who was challenging the Louisville Fairness Ordinance by saying that somehow being forced to engage in their expressive activity of taking these photos, even though they were out offering those services for pay, somehow resulted in a violation of their constitutional rights. So again, we're seeing a real shifting of the frame. And I think that thus far we've been able to hold the line in terms of where the doctrine is. But this is a perfect example of where the doctrine is and has been is one thing in terms of whether or not we should win these cases, but knowing that there is an affirmative multi-pronged attempt to fundamentally change what the law will be means that we can't approach these cases with the same degree of confidence that we will be seeing the application of standard, well-established law. We will see these cases as being the vehicles for fundamentally shifting our approach to these questions.
Yeah, I think that that's right. And one thing I wanted to add is, in a lot of these cases, the sort of opponents of the civil rights laws or the people seeking exemptions will just say, well, why don't you go to another store? Why don't you go to another adoption agency or foster care agency? And on the foster care side of it, I have a very personal view of it. I lived in foster care when I was younger. I adopted my own daughter out of foster care. And when you're discriminating against potential foster care parents on these types of bases, it's not harmless. It's not just that you go to another agency. That's more time it takes for that child to get the placement. That's more time it takes for that family to get approved. There's aside from just the sort of dehumanizing harm of being discriminated against on these sort of really troubling bases, there's the fact that this is leading to a disruption in people's lives in many ways. In a way that some might say it wasn't the same with getting a cake from somewhere else. But in the upcoming case, it really is alarming that we are at a point where the court could just sort of overlook that really extreme type of harm. Now, one thing that does give me a little bit of solace is that as you mentioned, the COVID cases, Sharon, is that the Supreme Court has recently in the last 2 months rejected several challenges to COVID restrictions. These are not COVID restrictions that only apply to churches. These are broadly applied COVID restrictions that apply to different types of gatherings, going to the movie theater, going to, whatever, dance club, different types of restrictions. And the court has rejected those in, a close vote, 5-4, and said, look, there is, there's recognizing, I think, at least implicitly, that there's this extreme harm and risk to others here. And so at least in these extreme circumstances, it seems like the court is holding fast to that principle. And hopefully that's one that the court will, do so in Fulton coming up this fall.
No, and Heather, your point is such an important one about sort of where the harm is happening and being able to sort of recognize that. And I think that to the extent that some of these earlier cases were really about going after businesses that people thought of being more trivial, sort of the florists and the bakeries, again, the notion that you would walk in and be rejected for who you are at any business, I think is important to sort of recognize as a truly deep stigmatic harm. But the fact that we're seeing this move obviously happening in child welfare spaces where I think people can recognize the harm, but also we're seeing now an increasing use of these arguments in the healthcare space. And I think in some ways that is a place where these arguments are perhaps the most dangerous and the most overreaching, and the place in which I think we have the greatest potential to bring the public along in understanding what the threat is that is presented by this notion that if you walk into the hospital that's in your community and it happens to be a Catholic hospital and you need, an emergency abortion or you need a hysterectomy, but you're trans and somebody doesn't think that trans people should actually get hysterectomies, even though it's part of your medically necessary care, and your religious healthcare provider gets to be the person who decides what you get and what you don't get. I think that we're seeing, the incredible recognition of how much harm that causes. But unfortunately, under this administration, we're seeing an emboldening of those efforts, both through the rolling back of the non-discrimination protections and the regulation enforcing Section 1557 of the Affordable Care Act, which was designed to ensure protection against discrimination, but also a separate rule that we are calling the denial of care rule that basically allows HHS to threaten to withhold funds from medical care providers that do not put religious objections of their employees ahead of the healthcare of their patients. We were able to get that rule enjoined. There were multiple lawsuits that were able to do that. Those cases are on appeal. I hope that if we wind up in a circumstance where we are able to shut those down permanently, either through litigation or through a change in the people who are controlling the levers. But the fact that we are seeing these kinds of arguments used in such a broad array of areas, I think that I'm hoping that the overreaching on the other side will also help us sort of shift the tide in a way that I think has been happening over a series of years, where people recognize that this isn't just to live and let live. There's actual harm that results when you allow people to basically opt themselves out of non-discrimination protections that are so important in able to secure these really important aspects of life.
Yeah, and this is a strategy.
We're coming up on the end of our time, so maybe Heather, would you like to take the last word before we end up?
Sure, and I'll try to wrap it up, just sort of referring to some of the other cases we didn't get to. But I think what Sharon is describing is this strategy that we've seen in a variety of the areas that were mentioned today, where you're starting out with something that seems so innocuous, not to us, but maybe to some more members of the general public. Oh, you can't get your wedding cake here. You can't get your photography here. Then we're moving into child welfare. We're moving into healthcare. In the funding area, you're not going to give this, church-run school money for a playground resurfacing. That's, why it's not a big deal. They're not doing anything religious there. And then the next step is, okay, well, now the next case is going to be something that is involving religious instruction, or as we saw in Espinoza, the court holding that it's a free exercise clause violation to deny funding for religious education. So we're seeing that we're seeing basically this strategy of trying to get these principles eroded based on seem more innocuous, and then very quickly moving to much more troubling claims with even more severe harms. And with the remaking of the courts, I think those more troubling advances, the effort to ratchet up the religious exemptions and religious accommodations, and the argument that religion is being discriminated against the courts are going to be more receptive to that if we continue in the path that that has been paved for the last few years. And so, yes, Sharon has typed in the chat, vote, 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 and I totally agree. The ACLU is also a nonprofit, nonpartisan organization, but as she mentioned at the top of the program, it's important to vote your values and to vote for people that are going to nominate and affirm judges that are going to take a broader view of civil rights, and one that is not going to allow religion to be used as a sword against fundamental protections that allow all of us to live and participate in our country and in our society.
Well, we have reached the end of our time, and I know there's so much more we could talk about if we just had a whole day to do it, but I think we've given people enough insight to maybe be concerned and go get involved, and like Sharon says, vote, vote, vote. And with that, I want to thank the panelists and thank everyone for viewing this presentation. Thank you all.